jury selection this time really did start in the Sarah Boone case, and they are in their second day of jury selection. So right now they're just trying to get enough of a potential jurors that can actually sit, and the time is not a hardship. And then once they get a pool of jurors, then they'll be able to begin the real voir dire, where the state's going to be asking them questions, the defense is going to be asking them questions. So they're really getting close to that point. So as it stands right now, the schedule is the following. Tomorrow morning on Wednesday, there is going to be a hearing, and this hearing is going to be with respect to the motions that were filed. A lot of them have to do with battered spouse syndrome, which we've already explained in our channel. We went through the motions, and it's a very important issue to see what they're going to be able to argue in terms of battered spouse syndrome. So that hearing is going to take place tomorrow morning, and guess what? Brother Counsel Studios is going to be live streaming it. So we will be live streaming it. I'll be giving you my live real-time commentary tomorrow morning, assuming that they start at 9 o'clock in the morning. Then after they're done with that hearing, and after you all join me for that live stream, of course, then after that, they're going to be shutting off the cameras, and then they're going to be continuing with the jury selection process, which will look like this. The state is going to be beginning their voir dire of the potential jurors, and then the defense is going to be asking their questions of the jurors. So how long that process is going to take, we're not 100% sure, but they're hopeful that opening statements will begin already Thursday afternoon. If it doesn't begin Thursday afternoon, then maybe Friday. If they don't conclude Friday, then obviously, Monday. But another announcement that I do want to make for everybody, and that is that starting tomorrow night, there's actually a Jewish holiday beginning, and therefore I'm going to be out of commission starting tomorrow night, Wednesday night, through the entire next week. So I will be out, and unfortunately, I will not be able to give you my daily breakdowns and analysis of what's going on in the Sarah Boone trial. But this is supposed to be a 3-week trial, and therefore, after next week, I will be doing my best to catch up on everything that was going on in the Sarah Boone trial and break down anything that I think is important for you to know as the trial continues. And of course, I do hope to be covering the trial from the second week on until I have a trial which begins. So my trial begins November 4th. So I'm going to be out of commission while my trial is going on, obviously. So, but don't worry, I am all prepared for this trial. I am very excited to do this trial, and I know it in and out, so don't worry about that. I'm going to be well prepared, even if I'm going to be spending some time looking at the Sarah Boone trial. So that gives you a little bit of a taste for the schedule for the next few weeks. And without any further ado, let's move into the motion that was just filed last night by the state. So here we go. This was just filed last night. State's objection and motion in limine to exclude decedent's medical records. Comes now, the state of Florida, by and through the undersigned assistant state attorney, and states and alleges as follows. Tonight, and what are they talking about? They're talking about October 14th. So this was last night at 9:51 p.m. So this is what they're saying. Tonight, the state received 550 pages of medical records regarding medical treatment the decedent, and of course they're talking about Jorge Torres, received in 2017 and 2018. The defendant acquired these records in January 2022. So why exactly did they wait till October 14th to share them with the state if they do intend on introducing them into trial? That is right away a question, an argument that we're going to be hearing from the state. You can't just try these cases by surprise. This is called trial by surprise, trial by ambush, and it's not looked at by the judge it's not well taken by the judge. He doesn't appreciate this. But anyway, let's continue. The state adopts all the arguments and authorities cited in the state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force. This is referencing the earlier motion, which if you haven't seen my video breaking that down, then definitely go check that out. But that was the previous motion that the state filed with respect to battered spouse syndrome that they do not want. The state does not want the defendant, Sarah Boone in this case, to be able to argue battered spouse syndrome until and unless she testifies herself to a justifiable use of deadly force. Now, we spoke already that the judge really already did not grant that motion that the state previously filed, but they're filing it again under a different title, and they do make some other types of arguments to exclude any mention of battered spouse syndrome. So this is one of the motions that the judge is going to take up tomorrow morning. So again, they're adopting everything in that previous motion. So they're telling the judge, remember everything we said in that motion and pretend we just stated it right here. And that's going to help them with their argument in this motion. The defendant, even in her most recent iteration of what happened on February 23rd, 2020, so again, a little dig at Sarah Boone that her recounting of the story keeps changing. So even in her most recent iteration of what happened on February 23rd, 2020, has not set forth the legal grounds to claim self-defense. Assuming that she does so at trial with a different version of events than prior instance of violence committed by the decedent, meaning Jorge Torres, that she was aware of, would be admissible to show the reasonableness of her fear of imminent great bodily harm or death. So just prior acts of violence is generally not admissible, right? That's a very basic rule. You're not just allowed to bring in evidence of either the victim or the defendant, other people's prior acts. You're not allowed to do that. But when you're arguing battered spouse syndrome and you're arguing self-defense, then you would be allowed to present evidence that you were the victim of domestic violence and to show that there has been a pattern. So this is, again, the state saying that only occurs once she takes the stand and is able to prove or show, at least in her version of events, that she was acting in self-defense. Once she makes that argument, then the state's saying, you're right. Then all this stuff can come in. All the violence that he committed in the past, you're right. Then that can come in. But up until that point, they're arguing that they should not be able to admit all of these medical records showing similar types of acts of violence. These records are irrelevant. So now they're arguing that these records are irrelevant anyway. 487 pages. So again, how many pages were there in total? 550. So of the 550, 487 of the pages regard an incident on December 24th, 2017, where the decedent, Jorge, was beaten so badly he needed facial reconstruction surgery. So actually, those pages, according to the state, would seem to actually help the state. So why would they not want this in? That's a good question. But he was beaten up so badly by her that he needed facial reconstruction surgery. And obviously, that would be he was really beaten up bad. This is not relevant to whether the decedent, Jorge, committed a prior act of violence that the defendant was aware of occurring. If the incident that resulted in these injuries is somehow made relevant, the severity of the decedent's injuries is not relevant. If the severity of these injuries is somehow relevant, then the defendant should narrow it down to the pertinent narrative history of what the decedent said happened and the treatment provided. This could be done in a handful of pages. So even if you want to introduce some of these records, it shouldn't be all of the voluminous 487 pages of it. Just pick out some of the pages, and then you can narrow it down to what actually is relevant to what the decedent said happened. Now, apparently, again, we don't see the medical records, but you would imagine that there is some sort of altercation in there. And it seems that they're going to introduce this as to show that, again, Sarah Boone was acting in self-defense, probably, against the decedent. So it could be that in those medical records, Jorge Torres is saying that he beat her up, and this was in response to him beating her up. So again, showing that there is this pattern of violence and perhaps Sarah Boone standing up for herself and acting in self-defense. So perhaps, and again, I'm going blind. I'm just assuming that could be what these medical records say. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hand through a glass window the day before, and his wife made him go to the doctor the next day. He received 2 sutures to close a 4.5 centimeter laceration. So what exactly does this have to do with anything? We're not sure either. Again, it's a 2018 incident. It is a history provided by the decedent that he put his hand through a glass window. What does it have to do with anything between any altercation or domestic violence between him and Sarah Boone? Not very clear. Assuming that the defendant testifies in a manner to make that incident relevant, a couple of pages of these records with the narrative of what allegedly happened and the treatment provided is sufficient to corroborate her testimony. So, if, again, she does testify that somehow this incident is going to then become relevant, again, you don't need all of these pages. You can just have a couple of the pages and some of those pages with whatever narrative they feel is relevant that could be admitted. And I guess this would be probably a good time to just stop and remind you about the sponsor of this video, the Suit Depot. The link is in the description. They sell a lot of very high quality suits and apparel, and for very reasonable prices. And on top of that, all of my listeners get a special 10% off. You're not going to get this coupon anywhere else. No other creator has this coupon. It's 10% off. All you have to do is type into the checkout box, the coupon box, Brother Counsel, all lowercase, no spaces, and you will get 10% off of that really, really high quality apparel. So check them out. The link is in the description. Continuing on with the motion. Burying the jury with 550 pages of records when nearly all of them are irrelevant, when giving the defendant every benefit of the doubt on relevancy, is unnecessary. And the probative, meaning even if we are going to say, you know what, maybe you can make some sort of argument that they're relevant, but all 550 pages are not relevant. So if you're just going to try to throw 550 pages of medical records at the jury and say, look, there's 550 pages of medical records that have to do with their altercations with each other and domestic violence with each other, that's not relevant, because 500 of them are very arguably not relevant. So therefore, the state is arguing, even if we would say that these pages are relevant and all these medical records are relevant somehow, then still you should, some of the records are relevant, not all the records are relevant. And the probative value is substantially outweighed by the danger of unfair prejudice. Again, it's unfair prejudice that the jury is going to think, wow, there's 550 pages of medical records detailing all the abuse. No, there's two incidences and maybe there's a few pages that are relevant to what's actually necessary for the jury to determine, but just to completely bury them with all these records, that's just unfair prejudice. It's a confusion of the issues, it's misleading the jury, or needless presentation of cumulative evidence for the statute 990.403. That's what we call 403, where the danger of unfair prejudice or the confusion of the issues or misleading the jury or cumulative evidence, when that substantially outweighs any sort of relevance, so then they should not be admitted. Therefore, the state objects to these records, barring their relevance being established at trial. Meaning, if you want to establish their relevance at trial, go ahead and take the stand. They keep daring her to take the stand, by the way. And their probative value not being substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence. So number one, they're not relevant. Number two, even if they are relevant, they're still substantially outweighed by all the danger of unfair prejudice, confusion, misleading the jury, as we just pointed out before. So that's the end of their motion. And this hearing is going to occur tomorrow. So that is going to be a very interesting day tomorrow morning. Definitely, you should all join me on the live stream tomorrow, when we're going to be breaking everything down as it occurs, real time. And then again, it's going to cut off and we're not going to be left with a blank screen, because they're going to continue with the jury selection. Well, that is going to be it for now. Please, if you haven't yet, subscribe, like. We're going to be keeping track of the Sarah Boone trial as much as I can. Of course, like I said, we're going to be taking a little bit of time off for the Jewish holiday, but we're going to be coming right back, catching up on everything and making sure that you get the analysis that only you can get from Brother Counsel. So definitely, please subscribe, like, and like always, we will see you next time.